resume. And the floor is now open. The first question or comment will come from Professor Abishabs. May he be given the mic. It's over.
Thank you, Mr. President. I just have a small comment rather than a question. When I was on the tribunal, I usually said, as a judge, I am bound by the principle of judicial caution, but as a professor, I can be irresponsible. Now I'm only a professor, so I'll speak a little frankly. We have heard very enriching comments from colleagues, very technical, etc. I would like to speak for just 2 minutes of how we perceived the problem at that time, in 1993. I start by saying that I consider that the rules of procedure and evidence, which were elaborated and then evolved, are perhaps, if not the greatest, but one of 2 or 3 peaks of the achievements of the tribunal. The problem when we met is that it was a very good mix, because we had many very senior judges. With the exception of 1 or 2 of them, they didn't have international experience, so they were very good at judging, but not with this. We had 1 prosecutor, Claude Jourda, and 2 poor professors of international law, and that was Nino and myself. So it was a good mix, because, but the challenge was, in comparison to what existed before. In Nuremberg, you have 2 pages and 3 lines, 12 articles, which were very, in French I would say lacunary. And the last article, I think Article 12, says, and the judges would improvise the solutions if they don't find them. So that's the threshold from which we went. But the task, at least as I perceived it, and I think my colleagues perceived it, was threefold. The first thing is what has been debated about the 2 systems and how to make a kind of a mix. Of course, every system has its own inner logic. You cannot just take one thing here and put it. It's like taking one piece of a car and put it in an airplane. It might not work. So the synthesis was not that easy. But secondly, in the meantime, we had the accumulated code of human rights, which is much more severe, that developed through the UN, and we had to integrate it. And third, and that is a very important point which was not mentioned up to now, you have to put all that into the international environment. Remember that criminal procedure is basically very internal law, and it has to be adapted to the international environment. I did tell my colleagues, 2 of them are here, the 2 ladies, I don't remember if they know, I say, we are like astronauts. We have to know how to evolve in weightlessness and try to see how these concepts, which are developed in very dense legal systems, can apply in a very ethereal environment like internet. And this is why we took about 8 months to produce the first set. It was Jules Deschênes, who was mentioned yesterday, who was the president. I was the rapporteur of this rules committee. And I think to some extent we did a very, very dense and important tapestry. Since then, of course, we went perhaps a little bit further in one way or less in another, but these have been marginal adjustments. The basis was there, and I think it will stay. It will stay, and this is a very important thing because, in fact, the credibility of a tribunal is that it seems like a serious tribunal respecting all the rules and functioning efficiently, etc. So that's it. Now I come to the anecdotes, and the anecdote is the 15 round that Gabi has mentioned against Nino. In fact, there were three civil law musketeers, and that was Nino, Claude Jordan, and myself, and we were pushing particularly about the in absentia. And it was not completely lost because Article 61, which was not mentioned, was introduced. The Article 61 was a kind of, it was what we called it reconfirmation of indictment. And it was that if we can't get the accused, at least the evidence which has been accumulated could be presented formally. It could later on be contested, but at least it would be presented formally, and there is a process of reconfirmation. And it was done, I think, for Milosevic, if I remember, or Karadzic. Karadzic, yes. So it was one way of showing what the tribunal has done towards the prosecution if this didn't exist. So, but I think this Article 61 has disappeared later on, again, because judges changed and so forth. So I say again that what has been done in terms of procedure is very, very important and will remain, and I think this is one of the greatest achievements of the ICTY. Thank you.
Sure. Yeah. Thank you very much. Thank you very much, Professor, for that historical perspective and for stressing the importance of looking at the rules of procedure and evidence in the context in which they operate, that is at the international level. Judge McDonald wants to make a comment.
I just wanted to comment because I wanted to remind George, perhaps, that yes, there was this concern about developing rules that would fit an international court, that would reflect the international character. But you will recall that the United States, not known for its civil law procedures, submitted a very comprehensive proposal for the rules of procedure and evidence. And in fact, we used that document as a model in the drafting of the rules so that we did not have to create them all over again, nor did we have to create the structure of the rules themselves. What we did was to make modifications. So these came from the United States, you know, and they were national lawyers. I told you I had worked on the rules with them, with the representatives from the State Department, Department of Justice, etc. The other thing is that, and I don't think I made this clear, but our rules were really, and this was a big effort, to fit the nature of the conflict. That's why we came up with, for example, such detailed, specific rules for, evidentiary rules for the trial of cases involving sexual assault. Not all of the judges agreed with the specificity and the high standards that we incorporated, but we did that, again, because of the nature of the conflict. And finally, Rule 61 that you make reference to was actually drafted by Judge Stephen, who was from Australia, former Governor General, and was on the Tadich panel. So here you have, again, a, quote, common law lawyer trying to at least propose a procedure that would allow the showing of the international community of the evidence, even though we could not seriously begin trials until we had cooperation from the multinational forces. So it was an unusual effort that we were making. 5 civil lawyers or 5 judges from the civil law system, 5 from the common law, and 1 from China, kind of a mixed system. Thank you.
Thanks very much. And just to remind the participants that the rule to which Judge McDonald refers, I think, is Rule 96. And an illustration of the high standard is not requiring corroboration of the victim's testimony in sexual assault. And of course, there are about 2 or 3 other subsections. I think that was indeed very, very thoughtful and highly commendable. Now, are there any other questions? Yes, there were several. Please just identify yourself.
Thank you. I'm Gerard King.
Yes, of course.
Appeals Chamber Special Court for Syria, past president of that court.
Yes.
I find the topic most interesting and fascinating, the interaction of civil and common law procedures. Because when I was appointed to that court in 2002, my colleagues, some of them were from the common law jurisdiction, others were from the civil law jurisdiction. And in practical terms, it took us some time to understand each other, our various approaches to the evaluation of evidence, for instance. So that's why I found that topic today exceedingly interesting and fascinating. Now, having said that, I think Professor Claus Kress mentioned the question of victims. I know that in the Special Court for Syria, there is no special provision for victims as such, victims who have suffered under the hands of accused persons, and particularly those accused persons who had been convicted. The worst atrocities you can imagine took place during that civil war in Sierra Leone. Now, there's no such provision for compensation of those victims. There is no fund from which they could be compensated. I know that there is no such fund also in the ICTY. I think the Statute of Rome provides a trust fund for victims in the International Criminal Court. I would like to hear the views of the panel in this regard, because justice just does not consist of trying and convicting accused persons. I think justice also should include the victims who have suffered at the hands of those who have been convicted. And not much attention has been paid so far to those victims. Thank you.
Yes, well, you would have heard me yesterday. I have been advocating some kind of assistance for victims of the Yugoslav conflict for several years. And I think it's a matter of regret that the international community has so far not come forward to support that approach. But I think we have made the first step. As I said, the International Organization for Migration in Geneva raised the funds, and that's very, very commendable, to carry out an evaluation of the needs of the victims in the former Yugoslavia. And I believe if that happens, it will set a standard which will be followed, or which should be followed elsewhere, in the court of Sierra Leone and elsewhere. So for my own part, I'm fully in support of what you have said, that victims need to be taken account of in the dispensation of justice at the international level, that the rendering of a judgment is not enough by itself. There needs to be more, and part of that more, I think, is rendering some kind of assistance, some kind of recognition. And one is not really talking necessarily about handing money over to victims. The victims really want to have their suffering recognized and acknowledged, and that can be done in many ways apart from giving people money. There are community projects that can be elaborated for the benefit of victims, and many other ways in which victims can be recognized. But is there any other member of the panel who would wish to speak on this? Judge Orie. Yeah.
I'd like to make a brief comment on it. I fully agree with Judge Robinson that you should care about victims. At the same time, the question arises, also in view of the dimensions of these cases, whether it should always be done in the context of a criminal trial. There again, I'm very much down to earth. When I was in the Cambodia Tribunal, which is based mainly finds its roots in the French system, I discussed with the judges there the position of victims, and they have got a place in the trials. And I asked them, does every individual victim has a right to put his claim before the extraordinary chambers? They said, yes, of course, that's provided for by law. I said, well, let's give a very low estimate. 1,000 victims? Well, of course, there are many, many more. I said, yes, they all are entitled to do that. Then I asked them, how many seats are there in the public gallery? And do you want to give the right to speak to those victims? Yes, of course, they are entitled to do that. Okay, 5 minutes for each victim, 5 times 1,000, that's 5,000 minutes. I mean, you have to be realistic. One of the worst things that could happen to victims is to give them rights on paper and not really caring about them and not really take effective measures to support them in their position as victims. That's what I would like to add.
Thank you. Thank you very much. Yes. Okay, Judge McDonald, and then there's the gentleman.
Real quick on victim, on the issue of compensation for victims. Some people suggest that has no place in a court of law, even an international court of law, because they would argue that the purpose of the court is to try individuals to determine whether the individual is guilty or innocent. But they forget that the mandate for the ICTY and for other courts as well was one of them was to help to bring about international peace and security. That cannot be done without addressing the concerns of the issue, of the victims, which of course would include compensation in one form, if not financial, then some other sort of recognition.
Thank you.
Thank you so much. I'm Bela Jimadikso, Judge of Trial Chamber 2, Special Court for Sierra Leone. I want to just contribute because we talk about fairness. Are all these procedures driven by fairness? Because fairness is something every judge owes to the accused person. It's a fundamental right of the accused. So fairness is just something every judge must guarantee to any accused. But the other thing is the truth-finding mission of the judge. Where do judges go to find what the truth is? How, through the procedures, they will just go to find where the truth is? Because I think the worst thing for any judge is just to make mistakes when it comes to the outcome of any trial. And judges are more concerned with which elements of the evidence, which pieces of evidence they may gather to find what the truth is in the trial. And I think, to end my contribution, it's not an opposition between civil law or criminal, common law system. It's about how to build a universal system taking into consideration all different systems to end up with something which is acceptable by everybody. Because even when you look at the way it's organized here, it's not about one system swallowing all the different systems. The common law system just imposing itself. I think Your Honor talked about this predominant system, which is the common law system. So how are we going to build now a universal system of law with a procedure which is acceptable and which is understandable. I think this is the mission we have as judges, I think. Thank you so much.
Thank you very much. Judge Van den Weingart wanted to say something.
Thank you. 2 points, starting with the last point that was made by my colleague from Sierra Leone. I think this truth-finding process and the way the judges feel about it is something metaphysical. I have served at the ICTY, I'm now serving at the ICC. I've worked with different colleagues, and working with common lawyers pur sang is very different from working with civil lawyers pur sang. A common lawyer takes a more passive attitude towards the case. If the prosecution has not managed to bring his evidence, that's it, and that's where the role of the judge ends. So the judge does not have to do more than to look at what the prosecution has brought and the way in which the evidence has been presented, and that's it. Whereas a civil lawyer, a civil law judge would find it his moral duty to go beyond that and to try and find, to make sense from the evidence that has been brought, even if the prosecution has not made sense of it in the way it has been presented. It's a totally different attitude, even a metaphysical attitude, which can create sorts of discussions between judges of different legal traditions sitting in the same panel. So it's quite interesting. I can't say more. I'm not in the luxurious position of Georges Abissab, who is now an academic again. I was an academic, now I'm a judge, so I'm bound by the restraint of my function. The second point has to do with victims' participation. I have sat at the ICTY for 6 years. I'm now at the ICC for 2 years. And a totally new system has been introduced at the ICC. And as Klaus Kress has said, the jury is still out, and the question is whether this system is really meaningful for victims. Because much of the ICC system is inspired by the so-called failure by the ICTY, which is blamed for having caused secondary victimization, which is the process by which victims, through their contact in the judicial process, are victimized a second time because of all the problems that they have. Cross-examination is often given as an example of secondary victimization. And so the ICC wants to improve on all this by allowing victims to participate in the proceedings and to give them reparations in the criminal proceedings. And that's the whole question, as Judge Orie was saying. It needs to be meaningful, because if it is not meaningful, then the whole question is whether this is not potentially another form of secondary victimization for which the ICC may in its turn be blamed. So that question is open, and it will need to be assessed once the first trials will have run their full course. What is certain is that the victim's participation comes at a very high price in terms of costs invested in dealing with applications, dealing with participation motions during the trial. So the certain consequence is that trials will probably get longer. So this is also something that needs to be assessed. So on that point, I would commend Judge Robinson. I think one of the very important things is for reparations to be, or for compensation to be guaranteed. And so here, I think this proposal that you have made a couple of days ago really will be a very important complement to the work of the ICC and to its success. Thank you very much.
Thank you very much. So perhaps tertiary victimization. Huh? Professor Klaus Kress, and then there are a couple others.
As I raised the victim issue, just a couple of additional thoughts. I think there will be no disagreement in this room about the principle that you raised. And this is a broad trend in comparative criminal procedure to, so to speak, to increase the voice of the victims, not just with regard to reparation, but as the trial is evolving. The problem, as so often, is below the level of abstract principle, how to make it work, and then, of course, with a view in this respect, very particularly in the specific framework of international criminal justice. I will leave aside the matter of reparation, even though that's fascinating in itself, and one could, for example, already reflect on what has happened in the early years of the ICC on Article 75, paragraph 1, where the judges had been asked to adopt principles on reparation, and what the outcome of this debate will finally be. Crucial point, I think, and not really to foresee at this moment in time, because not much has happened. On the participation issue itself, it was by no means an uncontroversial decision that was taken to give the victims a stronger voice in the ICC proceedings. There were many, many state delegations rather urging for caution and following the ICTY legacy in that respect. The international community has made its choice. In the ICC statute, I think that decision once made should be accepted, and now a very sincere effort should be made to give meaning to those provisions. But I would urge to do that in a spirit of fairness to the ICC at this moment in time. What I'm hearing already on quite numerous occasions, very severe critics to the ICC that proceedings are so lengthy, that the Lubanga trial has not yet been completed, and so forth. If you want to make a fair assessment of the length of ICC proceedings at this early stage, I think one has to take that point made by Judge van den Heuvel fully into account. Of course, obviously, it must add to the length of proceedings. The situation is more difficult now, where probably every decision concerning victims involves a new question, and judges have to, so to speak, to flesh out the principles that very often have been agreed by states in compromise form. So that's an additional factor to make it lengthy. But even if at one moment in time the ICC will have settled its jurisprudence on victims' participation, it will not be without price. And the crucial question then will be whether the state community will be ready to stick to the choice once made and support the ICC, this institution, even though trials inevitably have this additional impediment. What I would find utterly unfair is, on the one hand, place this burden on the court for festive speeches, and on the other hand, when the consequences have to be borne, criticize this institution for being longer. And then I think, secondly, this process, this procedural process should be evaluated and without any adversarial or inquisitorial bias. That doesn't help at all. It should be evaluated empirically and probably scholarly from the outside, so without any bias, to really see what this form of victim participation, which will not be a direct participation, but one through the intermediary of legal representatives, the forming of victims groups, and so forth, what really this means to the victims on the ground. We don't have these data now, to be honest. We can only speculate, and this is something attention should be given to, and I would encourage the ICC to allow for such research to be happening. And then there will be a moment in time where we have to re-evaluate and to see whether the choice that has been or had been made at a moment in time, for good reasons, for a very sound principle, whether it has proven on balance to be the way forward.
Thank you very much, Judge McDonald, and then that gentleman, and then Ambassador Gilbert Robots.
I quickly mention a book that reports on the study of secondary victimization and the trials of women who have been victims of sexual violence in the former Yugoslavia. The name of the book is Gendershamed, Sexual Violence by Sharon. as I said, it's a massive study of the way that the courts have handled these issues, and they're very difficult to handle. But it might be of interest to you.
Thank you very much.
This is a coincidence, but I'm Sarah Sharon.
Sarah.
And one of the professors has been emphasizing is empirical research. I did extensive work in my book on the former Yugoslavia, especially in Sarajevo, and the impact that testifying before ICTY and or the War Crimes Court in Sarajevo had on the survivors and women who had testified about sexual violence. Interestingly enough, most of them, and I had a sample of about 60, but most of them did not report getting traumatized by the court itself. They did not find it traumatic. They found it difficult, which is different than traumatic. And maybe I'm talking here as a clinical psychologist. So they did not find it traumatic. They found it difficult. All of them, with one exception, said they would testify it again if they were asked to testify it again. Therefore, I think our discourse about victims and victims testifying has to change, because many, many victims and witnesses are willing to testify. And in many cases, you're talking about the differences between a civil court and a civil and common law. In the cases of victims of violence, Judge McDonald and Judge Orie were leaders in introducing Rule 96, which allowed no questions of consent, which was later modified. That is not part of ICC now, which is, in my opinion, shameful. And in those particular cases, the cross-examination tends to be so severe and so discrediting to the victims, since women are not believed and there are so many myths about rape, that it's very difficult to evaluate which system is better or in general, but you have to look at the very specific instances in which the procedure is being applied. And thirdly, my last comment is my understanding was, and I'm not being condescending, I'm just trying to be clear, that courts were for victims.
The courts were
for victims.
For victims.
Victims, the justice of victims. And sometimes I think we tend to forget that. And one evidence of that is that there are no victims or survivors here. So I would like to say that, sorry, but the evidence in my case shows something else. Thank you very much.
So let me just understand you. So you're saying your research, and you're the person who wrote the book that the judge would refer to. I want to make that clear.
I just paid her to make that announcement.
I see.
Do you have a table set up outside?
Yeah, but so you're saying that your research, which is in your book,
yes,
does not confirm secondary victimization.
No, because it's a term, I'm speaking as a psychologist, right?
Yeah.
It's an overused term. People find it traumatic. And as one prosecutor, a male prosecutor, told me in the court, I have had so many men crying in the corridors when they're testifying about what happened to them. Crying, weeping, because testifying is very, very difficult. And a lot of times what makes it more difficult for in certain cases is because women are seen as being more vulnerable, which is not necessarily the case, but certainly the standards of proof in cases of rape and sexual violence are so high that they do find it difficult. It is very difficult to testify. That doesn't mean that they are traumatized forever or that they are not going to recover. That was my point.
Well, if you were to pay me as well, I will ask you to tell us where your book can be found.
My book can be found, it was published by Ashgate, it was just published in October, and also is in, the title is called Sexual Violence, no, it's called Gender, Sexual Violence, and Shame, the voice of court members and witnesses in war crimes tribunals. And I also interviewed many of the judges and members of the court about their attitudes and feelings about working in rape cases. And that's something that we don't pay much attention to, because in general, there were lots of judges who had a significant number of stereotypes about women and about women who have been raped.
Thank you. Well, you're assured of at least 200 purchases. Ambassador Gilbert Robots.
Thank you very much. Although I come from a background of international relations and I'm therefore a total layperson to international criminal law, I really found this morning's session fascinating. The first point I wanted was the issue of trials in absentia. I imagine that if the tribunal had proceeded accordingly, this would have decreased the pressure on the states concerned to have sought to brought the accused to trial. But that evidence would most certainly have had value at whatever point then the accused were brought forward. And I just wondered whether there was any difference in the approach, the criminal law versus the civil law approach, to the extent to which that evidence should be brought to the intention, not only of the international community, but the states concerned to bring pressure. And, how was that managed? And the second point is on the difference between the two systems on issues relating to adjudication and sentencing. But I wanted to refer specifically to the issue of early release. How did the two sides see the issue of fairness, the relevance, the appropriateness of the value of early release? I think, for example, on the issue of the responsibility to the populations concerned of releasing someone, I'm sure one wouldn't want to see a prisoner behave well or appear to behave well simply because he wants to be released. You want to be sure that you are sending back into the community someone who's really been rehabilitated. And then I know you have a percentage of the sentencing that has to be served before someone can apply. But that's a concern of mine, as I say, just coming from a background of international relations, issues relating to peace and security. How did the system see, the two sides see this issue of early release and how to treat with it in the context of its value? Thank you.
Well, the latter issue, I don't know if Judge Orie, who with some other judges assist me in considering applications for early release, would like to say anything on that. But you have highlighted the difficulty, essential difficulties that surround early release, of sending back convicted persons to their communities. We have many complaints from victim groups about that we release the victims too early. On the other hand, the practice is that after you have served 2/3, you can apply, And we take into consideration a number of factors, the rehabilitation of the person, whether the convicted person has been rehabilitated, cooperation, the demonstration of remorse, and a number of other factors. But it's not an easy issue. I don't know if Judge Orie wants to say something on that.
Well, I'll not say much about it. We usually get a full report from the local prison system. First of all, I'd like to make the following observation. Early release is in the many different systems dealt with in quite different ways. I know of countries where you can be released after having served 20% of your time. There are other systems where it's 2/3. There are systems where it's half. There are systems where, and that's also an important matter, where they make a distinction between their own people and foreigners. It's usually considered that being in a foreign prison is more severe than when you are in a prison where you get your own food, where you know your own people, you can speak with them, you can communicate with them. So it's a rather complex matter where certainly in the state practice there is not a unified system, or there's not. It's quite different everywhere. We have more or less developed a system where after 2/3 of your sentence there's a fair chance that you'll be released. Now, one observation. You said we don't want people to behave well because they want to be early released. I wish that with my children as well, isn't it? They would behave because they are genuine good people, good youngsters, rather than not to risk punishment or to risk whatever. I find that a very intriguing approach. I don't know exactly how to deal with it, to be quite honest, neither with my children nor with the prisoners.
Judge McDonald, quickly.
Just quickly on trials in absentia, and I won't present a brief against it or even for it, but at the front end there might have been some gain, because there would have been this showing of the international community that we were doing something, and that's really why we were established, because the international community itself could do nothing or chose not to do anything. But there would be little gain, and I think it would be detrimental in the long run, because the trials really wouldn't be considered legitimate. There are trials in absentia, and there are trials in absentia. If you accept the fact that the accused has a right to a trial in his presence, then you run into problems. Even in the United States, though, in United States versus Crosby, there is trials in absentia are allowed, but only if the defendant appears and then absconds, and then he is deemed to have waived his right to this trial in his presence. So it gets, it's philosophical, but there are some details that have to be considered as well.
Thank you. Professor Kress, and then Professor Popper.
Madam, on earlier release, I think you raised a very important question, and the whole area, I think, honestly speaking, is seriously underexplored. On a technical level, I think there is an additional problem that sometimes, at least in the relationship between ICTY and national states, the rules might differ, so there is an area of potential conflict, and I don't think these conflicts have often arisen in practice. One has sorted it out some way or the other, but in theory the problem is there. On a more substantive level, I think even more fascinating and important the question, what actually happens to the sentenced person once the international sentence is being enforced? Are there, you must recognize we don't have an international so to speak, enforcement agency like Spandau was to a certain extent after Nuremberg. So what is usually being done, the person is sent to a state willing to enforce the sentence. But to my awareness, the international level, the ICTY, but please correct me, they have not yet come up, so to speak, with guidelines to be observed by the national enforcement state in how to treat and in how to address perhaps the specific needs to internationally sentenced persons, those needs which arise with a view to at a certain moment in time, to send them back into their local population from a very distant place. But if this is the case, that there are no guidelines, which I just presume, this is not something judges are to be blamed for. International legal scholarship, international criminal legal scholarship has devoted very little attention to that area. You have a broad development. We have all started with looking at the substantive law, then we've moved to an extent to procedure, but with regard to procedure, we have focused on those parts of the proceedings which were of more burning interest. First, the actual trial, pre-trial, and so forth, and there is a really, to my awareness, a real need for and not just articles, but a monographic scholarly treatise of making sense of the enforcement of international sentence under the prevailing circumstances.
Thank you. Professor Kaplan?
Yeah, just a brief remark concerning the distinction between systems which separate adjudication and sentencing and systems which do not. I think this is one of the deepest and most significant distinctions in the criminal justice because it has a lot of consequences, and sometimes we are not aware of those consequences. For example, the relevancy in the admission of evidence. It changes a lot whether you consider the evidence relevant as to the proof of the conduct prohibited by the offense definition, or if relevancy has to do with the entire set of circumstances that you can consider in order to adjudicate and punish and decide the sentencing. Then it has to do with separation of powers. The principle of legality is very much related to the adjudication phase, while in respect to sentencing, a recurrent idea is that that power belongs to the judiciary, is an original judiciary power. And also I think the idea of citizenship and human rights is different, because when you have the separation, you might think that until you are a full citizen, so to say, well, the presumption of innocence shields you and you have all rights. But when the presumption is overcome by a verdict of guilt, then at that point you enter into a different status and you do not have any more the same rights. And that's why in the sentencing phase you might find no rules of evidence, lesser protection for the defendant. So I think it's very important to keep in mind that this is a basic distinction.
Thank you very much. Yes, gentlemen.
David Ray is my name. I'm judge of the trial chamber of the Special Tribunal for Lebanon. I'd just like to insert 3 brief comments into this interesting discussion. And I say that I've worked in 3 systems: civil, common law, and hybrid, mixed. First comment, the comments are precedent, totality, and trials in absentia. The first one is one of the distinguishing or defining differences between common law and civil law systems is the role of precedent, or stare decisis, which is, of course, in its simplest form, that the ruling of one superior court judge of a Supreme Court can bind every court in the hierarchy underneath, notwithstanding 3,000 other judges may disagree at the lower level with that ruling. And the ICTY moved towards adopting the common law role of precedent. I think it was in the Alaskovsky appeal, where it decided that its own decisions were binding on the trial chambers. So that was an extremely important shift in international criminal law. And I note that the bench was a mixed common law, civil law, although there were a majority of common law judges on that particular bench. The second one is a totality point, and that often when the differences are accentuated between the two great or larger legal systems of the world, I think my reading is about 80 countries use common law and about 120 or so use civil law. Often there's a misunderstanding about the totality, and the two systems are much, 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 much closer than you might imagine, especially if you take out the criminal cases, because criminal cases are a tiny percentage of any system. If you take out that 5% and move to the 95%, I can't talk for the United States, but in the other maybe not Anglo-American systems, the rules of evidence basically don't apply in most civil cases, in most non-criminal cases. And even in the higher courts with large civil cases, it's all done by affidavit, by statement, and cross-examination is optional. In the great bulk of tribunals, the rules of evidence don't apply, and the court informs itself as it thinks fit, but the evidence must be relevant and probative. So once you look at a system in totality, they're not as different as people often think. The third point I insert is on trials in absentia. And again, often when, and of course I'm working in a tribunal where that is a very active consideration at the moment. But if you actually look at the common law systems, again, I can't speak for the United States, but when people talk about it, they tend to analyse only the most serious criminal offences. In most, as I understand it, common law systems, there are a lot of trials in absentia, just not for the serious criminal offences. And I participated as a prosecutor in Australia in numerous cases heard in absentia for more minor offences in which a person could not be imprisoned in their absence and as long as they were notified that the offence is on. And basically the system would collapse in many systems if a lot of these cases weren't heard in absentia. So of course I acknowledge completely Judge McDonald's point about a person deliberately absenting themselves, but if you look again globally at these systems, there are not as many differences as people might think when they take the more superficial overview. Not that I suggest that anything said was superficial.
Thank you very much. Yes,
Sorry, I didn't introduce myself. My name is Harem Bush from the Zambian Embassy in Brussels. I think I will have no contest on the hybrid procedures, and I'm quite comfortable now, and at least I'm happy about the fusion that actually has been made in the procedure. The only one issue that I actually want to raise is about what Judge, you have been canvassing, campaigning on the reparations of the victims. I was trying to find out whether it is possible within the judgment, the rules on the judgment, that a provision could be made that the properties or the assets of the perpetrators of these crimes should be forfeited to the court so that they could actually be given, probably transferred, be paid to the victims. I don't know how possible that actually could actually come in. Thank you very much, Judge.
Yeah, we do have such a provision in our statute and rules for restitution. Any other questions? Yes.
Hello, my name is Mia Swart. I'm from Leiden University and Wits University in South Africa. I want to thank Judge Robinson for acknowledging the problem with the frequent amendment of the rules, that this could be seen as problematic, because this is something I think has been under-recognized by ICTY commentators and judges. So I would like to ask Professor Kress about this, because coming from a German background, the principle of legality, is something German lawyers are generally very sensitive to, the fact that rules should be clear, fixed, and certain. And I'm curious to hear your opinion about this. And then with regard to victims, I'm delighted that this has received so much attention in the discussion today. I just want to mention that I think that these trials are, unduly expensive and long anyway, so to lengthen it a little bit in the interest of victims wouldn't be such a bad thing. Thanks.
Sorry. Can you repeat the last part of what you said? Okay. To lengthen them would be bad.
No, the last part is more a comment on the comment partly by Judge Orie that trials are so lengthy and this would unduly perhaps extend existing trials. I just think that international criminal trials are very, very expensive to begin with, perhaps too expensive and too long. So to perhaps extend it a little bit in the interest of victims wouldn't be a bad thing. Thanks.
Would not be bad.
Would not be bad. No, it wouldn't be bad. It would be a commendable thing for the tribunals to take victims' rights seriously and not to hide behind excuses such as expenses, and they've been creative in other respects in terms of expediting trials, for example, so they can be equally creative when it comes to victims' rights and reparations.
I see. Okay. Yes?
Hello. Okay. My name is Edward, and I'm learning a lot, and I'm very happy about the success of the ICTY. One worry I have is to what extent, as one of the ideas is not only making justice applicable, but also contributing to peace, to what extent, after 161 people accused have been rendered and so on, to what extent this contributes to peace in the region? I live in Belgrade, and I see that the Serbians consider themselves still punished today by the crimes of Milosevic. I saw yesterday one presentation by an NGO, then presentations by people from governments, showing how important had been the pressures so that these accused criminals would be given to justice. Okay, but to what extent is there a recognition, thank you, that the government in power, I mean, if you think of President Tadic, he and many of his allies have been in the fight against Milosevic since the mid-90s. If you remember, Milosevic fell in October 2000. There were international pressures, of course, but there was a huge social movement there. Serbia today has a rate of unemployment of 22%, probably among young people it's around 30% or more. It's a very, very difficult political situation. And I remember when Mladic was arrested, CNN said the following: oh, okay, he was arrested, but why did it take 16 years? As if there had been simply bad will on the part of the government, when what actually happened was a very, very tough political and institutional struggle. Because as you know, for many people in Serbia, as a defeated country, Mladic was a hero and not a criminal. So I'm just trying to point out that these questions are sometimes very, very complicated. I am very happy with the success of ICTY. I think it's great. The question, as always, is that human rights are basic as a principle. But of course, you would remember that Turkey has been forced to abolish capital punishment so that it can have the hope of, at a certain point, trying to join the European Union. And if we think of human rights and statistics, the state of Texas, in isolation, executes more convicts than the other 36 states where you have capital punishment in the United States. Okay? Again, in statistics, nearly 90% of people in Serbia are against NATO, because in 1999, Belgrade was bombed during 70 days, from March to May. So I'm just trying to bring some aspects here. And of course, it's easier to have a court functioning against defeated and reasonably powerless countries. So the great thing with international criminal procedures is when powerful countries can be submitted to those. Bombings of civilian populations, be it in Asia or in Europe, this has happened in the past. No one has been punished. So this is a great precedent, ICTY. I'm very happy with it. I only hope it can extend also to powerful countries. Thank you very much.
Yeah. I certainly agree with that sentiment that where powerful countries have been delinquent, that they should be held as accountable as others. I believe we can have just one more question.
My name is Angus Kelly. I'm from the Prosecutor's Office of Bosnia Herzegovina. Just an addendum to the lady who was speaking there about research on gender violence. Very short observation from the coalface, so to speak, that I don't deal with gender violence cases, but in mass killing cases, I can tell you that two of the biggest problems we face every day are witnesses testifying and their refusal to do so because they're afraid or because they've got witness fatigue because they've testified so many times, and witnesses being threatened. And those issues are ongoing and happen every day in Bosnia. So I just think that's important to recall and remember. Thank you.
So you are not in agreement then with...
Well, I can't speak for sexual violence crimes, so it's a different issue. But what I can say is that in the cases I deal with, which are mass killings cases, victims are refusing to testify for a large number of reasons, including the fact that they don't want to relive these experiences. They are afraid of those who live in their communities or who live nearby. And I know this from talking to my colleagues in other jurisdictions where they prosecute people in those jurisdictions, that they have the same difficulties when they come to Bosnia and also with people living in the emigrant diaspora around the world.
I'm not sure whether you actually contradict her point.
No, I'm not saying it was contradicting it. It's an addendum.
Her point was that court proceedings.
Yes, but we're involved in court proceedings.
Secondary victimization.
Yes, but I'm not saying I'm contradicting it, it's just an addendum to it. Thank you.
Thanks. Just one more question.
Hans van Houten, I would like to add a second addendum to the rape issue. Some years ago I was chairing the Ethiopian Eritrea Claims Commission, where we also had a lot of rapes, and our impression was that in an African context you cannot find witnesses about rape because if you testify that you have been raped, you're ostracized out from society. And therefore, let's say in our commission, we accepted the fact that a woman who, after having delivered her baby, refused to see it as an indication that there has been rape.
Yes, yes.
I want to respond to this, that because it comes from the president of the tribunal where I am now working, around U.S. Claims Tribunal. And I want to express my views really quickly. When I was at the ICTY, I confirmed a number of indictments, and I often heard from the prosecutor that it was having problems bringing to the tribunal persons who had been raped, and that was why they had not charged sometimes in the indictment rape or another form of sexual violence. What I found in a couple of instances that in fact within the file there were affidavits, or we call them declarations, of women who were willing to testify about what had happened to them. So that instead, I think that's the vision or the attitude of the investigators, most of whom were men. I think that's changed, Hans, and I think that that's really no excuse not to at least approach the victim, and with a proper investigation done by gender-sensitive men or women who are gender-sensitive themselves, the problem is not as great as some may say.
Well, I want to thank you all for participating in this discussion. I found it very interesting, and I hope you have also. We could go on, but you have been given 1 hour to participate, so the panel has been true to its word. Thank you very much.
Can you take me back?
Like yesterday, the lunches will be served in the corridors, but unlike yesterday, we resume at 2 p.m. Bon appétit. See you.